Buenas tardes a todos. En el día de hoy, en vez de hacer un Facebook Live, pues vinimos entonces aquí a las oficinas de Ser Familia. Estamos aquí con la directora ejecutiva de Ser Familia, Urbina. Gracias por tenernos y por invitarnos en el día de hoy.
Muchas gracias por haber venido y gracias por la información que le van a dar a todas las personas que están aquí hoy.
So, full disclosure, ella es mi mamá, para que no lo sepa. Pero estamos aquí realmente pues, para ayudar a la organización y entonces a otros líderes de la comunidad a hablar acerca de algunos cambios de inmigración. Y pues a continuación van a ver las preguntas y la información que presentamos. Como siempre, al final entonces vamos a tener un pequeño mensajito para ustedes, pero espero que disfruten la información.
So, just briefly, just so you guys know a little bit about each other, we'll briefly present ourselves. I'm Michael Urbina. I've been an immigration lawyer now for about 8 years. Before that, I worked for another firm for about 3 as a law clerk, and before that, I had an externship with ICE, the prosecution office here in Atlanta. So I've been involved in immigration for a while now, on both aspects of the law, and I'm married. I have 3 daughters. They drive me nuts a lot of days, but gotta love them, And we have our office here in Marietta, Georgia.
All right, so I'm Carla Verma. I've been an attorney for 2 years. Before that, during law school, I did get involved very much with immigration. I used to do a lot of agricultural immigration type of deal, making sure that the people at farms in South Carolina were up to OSHA standards and things of that nature. I am married. I have no kids. I do have a dog, and I am fostering puppies at the moment. And that's about it for me.
Hi, I'm Gadiel Rosario. I'm from Puerto Rico, same as Carla and Michael. I've been an attorney for over 9 years. The first part of my practice, I did it in Puerto Rico before I moved here. Did a lot of real estate and commercial contracts and that kind of subject area. I moved to Atlanta on 2014. And I joined the Urbina law firm a little more over than a year ago. I'm enjoying it. I'm learning a lot from these 2 colleagues, and we're excited to be here and to answer all of your questions. Thank you.
So Gadiel's in the unique position that he's the newest attorney in our office. At the same time, he's the oldest attorney from the 3 of us. So
he loves saying that.
I had to throw that in there. Sorry.
I'm the youngest.
She likes to throw that in there too. Thank you, Carla. Great. So this conversation that we're having today really started as questions that we were getting with regards to public charge, which will be our first topic of the day. So public charge is a section of the law basically that somebody can be denied a visa or admission to the United States as a resident if an officer determines that that person is likely to become a public charge. In essence, that they're going to become a burden on the economy, but more particularly on the government, meaning that they're going to apply for certain programs. The reason why this is an important subject is because last year they announced that there's going to be a new rule where they're expanding the public charge aspect, which unfortunately it was not, in my opinion personally, not properly reported or not properly informed to the community. So everybody thought that if you were obtaining or acquiring any kind of public benefits from the government, from the federal government, the state, anything, you were going to be denied no matter what you were applying for. That's simply not true. The reality is that they have expanded certain areas, or they changed the way they go about determining public charge, which in the past was really just with regards to your ability to have a sponsor or for you to fend for yourself economically, or the likelihood of you obtaining benefits based on certain factors. But there was no parameter really in how to determine a public charge other than if you had a sponsor, the government didn't look at it at all. It was just like, you have a sponsor? Okay, we're done with you, no public charge. But now, even if you have a sponsor, they're gonna look at other factors to determine whether that person is really disqualified to be able to obtain. It can be, again, a non-immigrant visa, a visa to immigrate to the United States, aka getting your green card or your lawful permanent residence. And that is really what has been miscommunication with regards to how people go about applying in the process. So what the new rule does is essentially it establishes a certain set of parameters to determine in the totality of the circumstances what is going to become or what is going to be considered a public charge. At this moment, the reality is that it's mostly being seen in consulates all over the world. USCIS, which is the local immigration, office that determines benefits with regards to work permits or green cards, they have not really started to use this rule yet. They can. There's no real reason why they haven't. They just haven't been given guidance with regards to how to go about it. But we have noticed in interviews that they're asking more questions about it. So they are delving into it, but there's no clear guidance for the local officers to go about it. Now, in the consulate, when people are trying to come into the United States, they do have a clear field guidance parameter on to how to go about that. So just so I don't leave anything out, so that they consider certain factors, specifically 7 factors that they look at in determining the likelihood that somebody becomes a public charge. So a person's age, their health, their family status, assets and resources, their financial status, and education and skills, okay? So age, unfortunately, immigration is completely discretionary for the most part. They can choose to discriminate if they want to. So if they determine that someone is of an older age and they think this person is likely going to become a public charge in the sense that they're going to be seeking government assistance for a health situation, for a mental problem, for anything, the reality is that it's more likely that that person is going to be considered a public charge. Health, the same reason. If you have a particular serious condition, it can be physical or mental. It does not have to be just old age or anything really that it can be visible. They can consider mental health an issue to determine whether you are a public charge or not, okay? There are certain diseases mostly focused on TB or STDs that will make you inadmissible, but they can consider really any disease whether you can be subject to the public charge aspect or not. So for example, even though cancer is not listed as an inadmissibility disease for purposes of immigration, they can consider the fact that you had cancer currently to determine whether you're likely to become a public charge.
I'm sorry.
Yeah.
I don't know that term.
What term?
Public charge.
So public charge, like I mentioned at the beginning, is the government determines whether a person will become a burden on them or the economy. So that's the term that they utilize to determine whether an individual will become a public charge. So if somebody's going to become, dependent on Medicaid or something like that, then they can determine whether that person in particular is a public charge.
Thank you.
Okay? Assets, resources, and financial status, although that's separate, is the reality of circumstances. They're looking to see what is the likelihood that that person has to use public benefits. So if you have a house or you have property outside the United States, inside the United States, or you have an immediate relative, your kids or your spouse has property, then the chances of you becoming a public charge are less for the fact that you could sell that property and avoid going into, a situation where you have to ask the government for help. Same thing with retirement accounts, think of that sort. Inheritances, if you have an inheritance, you can consider that to show that, hey, I'm bound at this point. I'm in the probate process to be able to, acquire this inheritance. That's something you can use in your favor, okay? Same thing with education and skills. If you're someone that, you may not have a bachelor's degree, but you've been working in engineering for 20 years, so the chances of you really being employable over the period of time is more likely than if you don't have any serious experience. And same thing with your education, okay? So they take all those factors in determining whether somebody specifically can become a public charge or is likely to become a public charge, okay? That parameter didn't exist previously. It was more like 100% whether the officer liked you or not. So if the officer saw you in raggedy clothes and said that you maybe looked, a little more on the underserved part of the community, whatever you want to call it, they could determine, this person doesn't look like someone who's really going to be able to fend for themselves. So they just made whatever decision they wanted, but now they have these specific factors to consider in a formula to determine whether public charge exists or not. Now, with that said, this is where it gets tricky. Being a beneficiary of benefits in the past is part of that formula, okay? Even though it's not in those factors, they do mention it within the regulation, okay? And this is where everybody's freaking out about this particular aspect, is what benefits qualify or not. The reality of circumstances is that the vast majority of benefits that, the people you serve, the people we serve, obtain do not make you eligible for to be a public charge. So if you guys want to start throwing names out there in terms of benefits, like the WIC program, that's not a problem. Emergency Medicaid, not a problem.
So we're with the school system,
Mm-hmm.
and we have seen a lot of resistance with families
Yes.
Because they have had, I'm assuming, misinformation that could be seen as a public charge.
We've got that question a lot too, and it's not going to be a public charge issue.
Do you have any advice on how we could communicate, or do you have any information that we could possibly ask to be posted in, say, our food and nutrition website to communicate that?
So I'll do the exact same thing I did for a few clients that were posting. So we do a lot of stuff on Facebook. So we have a client that posted a video of another attorney saying all these terrible things about the public charge and whatnot. I'm like, that's not correct. And she's like, well, how do you know? I'm like, I literally just sent her the link from USCIS that lists program per program which are beneficial and which are not. USCIS. So you can literally Google USCIS public charge, and the first link is a USCIS page that literally goes into detail as to which federal programs. They won't go state by state. They will make some mentions of different states' programs and whatnot. But in general, most of the benefits that people apply for are federal benefits, or at least, federally funded. And the reality is that most of them are not, or most of them that people apply for are not going to be something that concerns them with regards to public charge.
For those who are curious, USCIS stands for United States Citizenship and Immigration Services.
What she said. Yeah. So, like I was saying, so just to go over, so the, yeah, go ahead.
Yeah, and I have a question too about people seeking child support services. Is that a part of those public services, or?
Child support is not a government benefit.
It's not.
No. So child support comes from the parent or the spouse.
No,
So
but like the agency that enforces child support to be paid. So.
it's not. So no. They don't. The only time that honestly child support comes into play with regards to immigration is for parents that are applying for some sort of benefit in court. The only time I've seen it is a parent that's applying for some type of benefit in immigration court, and right before they are about to approve the case, a judge is like, wait a minute, do you owe any child support anywhere in the world? And the government might start looking into that, and they're like, okay, get yourself up to date with your child support if you're not, and then we'll just grant your case. But it's so rare for child support to even become an issue. I mean, I've seen people that owe decades of child support go through a consular process and get their green card, and the minute they get the green card, that's when they're like, oh, should I go back and pay everything? I'm like, well, you didn't do it before. Or, I mean, are you going to start now just because you want to, or just because you think they're going to take it away from you? So the reality is that child support is not even on this list mentioned at all whatsoever.
That's so good to know.
Yeah.
And a stressor.
Mm-hmm. So I mentioned housing benefits. So I'll just read off some of the biggest ones. So CHIP, that's not going to be a problem. Medicaid or other health insurance services.
Just teach here.
Yes, not a problem. Education assistance, like going to public school, getting school lunches, things like that, not a problem. In-kind community-based programs like soup kitchens, crisis counseling, interventions, short-term shelter, not a problem. Where it starts becoming a problem, really, it's the biggest way to determine is whether the person receives a cash-based benefit. Okay. Most of these programs that people apply for, they don't get cash or even checks for them personally. They might get vouchers, they might get reduction, but they never actually see cash going through their hands. So they see it in an account somewhere, but it doesn't go directly into their account. It's really more when you get in like Social Security, income supplements. Those is when you start treading water where you're like, that's questionable, okay? And the reality is, so just this entire page here that I have is of benefits that are not going to be a problem for public charge. And then the benefits that are going to be an issue, it's just this one paragraph here, okay? So the reality of the situation is that, yes, it's something to be concerned of because it's a change, but honestly, it's something that was so grossly misrepresented in, the public that people just freaked out over nothing, okay? Because the vast majority of services do not count. Now, Gadiel and I were talking earlier, and that was the best way for me to explain it to them, in general, we're talking how do you go about explaining this, is that if you are obtaining Social Security income or any other kind of cash system or general assistance program from the state and from the government, you likely committed some type of fraud if you have no status in the country. Meaning that if they are getting that, your problem is bigger than you being considered a public charge.
Exactly.
Is that you likely committed a crime that is further going to disqualify you from any immigration benefits.
What about the people who are victims of crimes and they have those victim compensation programs from the
state?
mm-hmm.
Not
they
a problem.
refund them for all the stuff that they've paid for because of the crime?
Not a problem. Yeah.
The fear of a lot of people is like for the adults, they don't have status.
Mhm.
They have children born here, and if they were, the child has a health issue or something, and it's on Medicaid or receives any assistance, the rumor out there is that the parents will get in trouble for that.
No. In summary, no. So the reality is that.
Yes, repeat the question, whatever they
So the question was that, the rumor or the concern of people really is that if they're getting all sorts of benefits for their children, not necessarily for themselves, and the parents are undocumented or don't have the proper status, then at that point they're going to get dinged in the future because their kids are receiving, whether it be Medicaid or whatever else it is. If the kid is entitled to it, and again, it falls under this programs that we were talking about, it's not going to affect them at all. Especially with regards to kids being entitled to. I've seen specifically, like she mentioned back there, the lunches. I mean, that just broke my heart because there were a lot of people saying that I don't know how I'm gonna keep up with the lunches for my kids and everything when I can't apply for that anymore. I'm like, why not? That's not a problem in any way, shape, or form. Same way that they were saying, well, now my kids don't have health insurance because I had to take them out for this. I'm like, that's not gonna be a problem. So the reality is that a lot of people out there just think fear right now is the biggest enemy of everybody. Unfortunately, what's happening, I mean, let's call it A's and A's, the administration is driving, and we'll talk about that a little bit later, most of the policies are just driven by fear, So this is just another way of them trying to, put pressure on people to try to hope that they leave on their own rather than, address the real problem, okay? So that's in essence the discussion with regards to public charge. It's really not that complicated. I understand that a lot of people, and I've seen a lot of people go on TV saying that it's not. I mean, that is supremely complicated. It's not. It's very simple. USCIS has a one-page description of everything that qualifies and what doesn't. It's just that, unfortunately, there's been so much misinformation that everybody's confused and rumors spread wildly in the community. And it's just something that for a lot of years, everybody was concerned about benefits. But now when this was brought up, it was just, fueling the fire. Okay?
Michael, I think that what you're saying is important, especially clarifying SNAP benefits, food stamps. Because one of the biggest problems that we see as an agency is kids going hungry because the parents are so scared and they are just letting their SNAP benefits, expire. So I think that's I just wanted to reinforce that part because probably the nonprofits present here, probably that's going to be your biggest issue is the kids that we serve being hungry because parents don't want to have SNAP. So it's great to know that that's not part of it.
That's actually point number 4 on the USCIS page. Nutrition programs, including food stamps and the Special Supplement Nutrition Program for Women, Infants, and Children, which is WIC, the National School Lunch and School Breakfast Program, and other supplementary and emergency food assistance is not considered for public charge. So, again, the biggest and best source of information is, we say in Spanish, la boca del lobo, like it comes from, the wolf's mouth. Like, they're telling you very clearly what qualifies and what doesn't. And they're on their own telling you that the vast majority of programs that people do apply for are not considered for public charge purposes. The only time that that's going to be a problem is, again, if you apply for these benefits in a fraudulent way, okay? So you can look at this page thoroughly. You can see, you can use that and post that in your, in your office if you need to. It's usually the most clear way of you being able to determine what qualifies or doesn't. But again, the vast majority of programs that people, try to apply for are not, going to be a problem. Yeah.
About the dreamers, they are covered with this too. I mean, because they are not in a process. I mean, they have status, but they are not in a process. So one of the questions we receive is they are just afraid to apply for Medicare or in a situation when they are pregnant, for example.
Mm-hmm.
We have a client who's pregnant right now. She's a dreamer, but she don't know if she can apply for any kind of post service because her husband is trying to, apply for her to be a permanent resident.
Mm-hmm.
She's in the middle, so
Yes.
she's fine with that.
She's
She
fine.
can do it?
Yeah. Again, if it will cover and it will be fine for people that have no status whatsoever. If you already have, DACA and TPS, I like to call them like quasi status because they are sort of a status per se, but it's so easy to lose it. It's also so easy for you to fall out of those status that it's just hard to say like, oh, you're safe with that, So, but yeah, that's not gonna be a problem. Okay.
Can I ask if she's already getting the community that she needed?
Yeah, she's still about to just ask for the primary care.
Okay.
I mean, she has like 2 months, but she knows.
So let's talk at the end because I'm going to be looking at the next of car.
Okay.
She can get her.
Okay. So we're going to move on then to the next topic, which is Carla. She's going to talk about some of the domestic violence reliefs that are available generally for people and just some of the updates with regards to what's happening with that.
All right, so first up is VAWA. VAWA is, again, Violence Against Women's Act. Doesn't necessarily only apply to women, it also extends to men. Those are for people who are married or have been married to a U.S. citizen or a lawful permanent resident who have also been victims of abuse. They have to be able to prove that the person is either a U.S. citizen or a lawful permanent resident. They have to be able to prove that their marriage was entered in good faith. That means that they didn't marry them knowing that they were just going to get abused to then apply for this benefit or just so that they could get immigration paperwork. This has to be that they got married because they loved each other and wanted to have their life together. They also, if they are divorced, they cannot remarry while they're applying for this benefit. It's only good for up to 2 years from either the divorce or the abuse. Do you guys have any questions on that one before I move to the next one?
Reported abuse?
So not necessarily. If they have documentation, it always helps the case and makes it stronger. Remember that these are reviewed by an officer and he just looks at the evidence. He's not gonna look at the person or take a lot of testimony most of the time. So they're just looking at evidence. If there's not that much evidence, then the case is gonna be a lot harder. But it does not necessarily have to be documented abuse. It could be letters from people who witnessed it. It can be a psychological report. It can be different things.
This one is self-petition, right?
Yes. So that means that what she said was self-petition. That means that it doesn't have to be petitioned for by another person. The person themselves who is the victim of the abuse can apply for this benefit. Or if the person is the mother of a child, or I'm sorry, the child of a U.S. citizen or lawful permanent resident, then the child can also apply. It doesn't necessarily have to be the spouse. Okay. All right, so the next relief will be a U visa. That's called a humanitarian visa. That's the one that we probably hear about the most. Those are for people who have been victims of certain qualifying crimes. Again, domestic violence is one of them, assault, battery, usually crimes that have to do with physical injury. Those visas are used very often, so the backlog is huge. Right now we're seeing that they're taking anywhere from, correct me if I'm wrong, around 8 to 10 years, what used to take 4 yees.
When I started, it was 1 year. So
That's how long ago he started.
zing.
Exactly. They, again, used to be that you would get a deferred action while you were waiting for your visa to become current. We have not been seeing those anymore. So you're basically 8 to 10 years hoping that you don't get arrested or have any problems with immigration because, again, with the administration, what's happening in court, it doesn't matter if you have a U visa pending because U visa forgives or waives deportation orders. The judges are saying that, hey, You can just take a deportation order, go back to your country, wait it out over there, and then come back in when your visa is available. So we're seeing that in a lot of cases, it's not necessarily giving as much protection as you would like. It's just kind of a safe hold in the future. Okay.
And the reason for the backlog is that U visa is under the Violence Against Women's Act, has a 10,000 total cap per year, meaning that they keep reaching the cap every year. So all those numbers that have not been reached, then they go into the backlog over and over and over again. Right now, there's over 122,000 pending visas. So, and it's likely going to keep increasing, every year that goes by. So the reality is that you could very well, like she said, be waiting for 8 to 10 years, and you may not get a deferred action at all, or if you get it, it's closer to, 6 months before you actually get your actual U visa.
Wait, quick question. When you say deferred action, what do you mean with that?
Okay.
Sorry. I don't want to intrude,
Oh, well, we're past that. But deferred action. Basically, it means that they're going to allow you to remain here. Again, it's very similar to DACA. It's not the same status. It just means that we're going to allow you to stay here. We're going to give you a work permit, but you don't necessarily have a status. You're also in limbo. Anything else? No, you do get a work permit. At that point, yes. Before that point, you don't have a work permit until you get your visa.
During the long waiting process.
Correct. 8 to 10 years, no work permit unless you happen to be one of the lucky people who get deferred action, and it depends, like he said, on when in that time you get it. You're not going to get it at year 1 when you apply for it. You may get it at year 9.6 when you're about to get your U visa. I saw some hands.
So when you apply for your visa, can you say kind of like work visa right away, or?
So no, in order for you to apply for any employment visa, you have to have legal status. You cannot be undocumented and apply for any work visa or any type of visa.
But meantime, your visa is pending. Can't you apply for the employment visa?
Because at that time you don't have status. You're just waiting to get status.
And that's a waiting pending period is of 8 to 10 years.
Yes.
And if the person like found a love and want to get married, can they cancel their U visa, or they have to be on this, the
So they're not mutually exclusive. You can keep your U visa just in case, because you never know, and then go through your marriage-based application.
Okay, so they can still send
Yes.
another status application.
Yes.
No. Now, the minute you get your green card, your visa will be canceled. So it'll be denied as moot because you have status at that point. So you can
When
keep
you get
it.
your permanent residency.
Correct.
Yeah, but I can have another different status, right?
Well, if you go through a spouse, if a spouse petitions for you and you become a green card holder, then at that point you can be a green card holder and a U visa holder at the same time. So if you become a green card holder, your U visa will be denied.
And that's the best one. You want to be a green card holder.
Yeah.
You don't want to have your U visa. Yes.
Correct. Now, just to be clear, when you were saying employment visa, did you mean work permit or actual?
Work permit.
Okay.
Okay.
So you can get a work permit if you get deferred action, and you can apply for a work permit based on deferred action at the same time that you apply for your U visa. But the reality, again, is that we had a client that got their deferred action granted a month and a half before they got their U visa. So it was kind of pointless to get it at that point.
Efficiency at its best.
Yes. Yes.
So you said that a child can petition this visa for their for the parents, right? How old does the child have to be?
Under 21.
They can be under 21.
Hmm. And then also the child does not have to not have status. It doesn't matter. The child's status is unimportant for whether or not they qualify for this benefit. For example, let's say you have an 18-year-old U.S. citizen who is the victim of a crime. Even if the person who has the crime is a citizen, they can still help their parents out by them being an indirect victim of that crime because they're minors. Now it gets a little trickier getting officials and solicitors to sign off on those, but they are eligible for that benefit themselves.
What if the mother's undocumented and the child is a U.S. citizen and the child is an indirect victim of that crime?
we could still probably make the argument that because the child is a minor, the mom would also be an indirect victim. Any other questions on U visas?
I usually tend to do the letters for parents who are applying for the visa U as a clinical standpoint, as a mental health provider. Has there any updates been done? What can I do to help them with those letters? That's my question.
So I would say that those letters would primarily should focus on the harm experienced, because that's the basis of it, and how that harm is going to affect them in the future, how it has affected them in the past, in the present, and in the future. Kind of document that this isn't just a one-time thing that it happened to them and they're over it. It's something that they're going to have to battle to get through. Right?
Very good.
And the other good thing about U visas is that you can have derivatives. That means if you are a parent and let's say your child who's 14 and a U.S. citizen experienced the harm, you get it, and that means that your spouse gets it, and any other children under 21 also get it. So it kind of covers more people than most of the other reliefs.
Can you say that again?
Yeah. So let's say I'm the primary person applying for the U visa. I am married and I have children. My spouse, they have to be legally married. My spouse gets it, and then any children under 21 get it. Now, if I am under 21, that means that my parents get it, and then it's possible that some siblings may also get it depending on their age.
The siblings have to be under 18
Yes.
to get it.
Question, so as a victim of domestic violence, the mom is the primary victim, the child who's under 18 is the secondary victim. Can that child apply for the U visa instead of the mom as being a secondary victim and being harmed also and going to therapy and all that? Can he apply for that mom and the rest of the family?
Yes.
Even if the mom is a primary victim, but there's.
Yes.
Okay,
Yes.
thank you.
And would you have to show that DFAX is involved?
No. Most of the time, these are signed off by police officers. So the best scenario would be that you have the people listed as victims on the police report, because that makes it easier for them. They don't have to think about it. They see victim, they're like, yep, I'll sign off on that, when they're feeling in a good mood.
No.
Can you talk a little bit about when a U visa is taken away because of non-cooperation?
Yes. So U visas, again, are for victims of a crime who have helped and are going to help in the investigation. That's what the police have to sign off on. So a person that submits their U visa and then they're like, oh, I'm gonna forgive my husband for hitting me, and they go to the court and then they withdraw the charges, that means at that point they have lost their U visa because they are no longer proceeding against the person.
Another question. Pine, who is a victim of domestic violence, she is an immigrant. I took the paperwork to the police department for her U visa to be signed off. But he wasn't able to be served with the protective order paperwork because he was evading service. There is only one police report because she was afraid to go to the police or call them, so I went with her and we did all that. Does she still qualify to be able to apply for the U visa, even though it was no arrest? He couldn't get served with protective order papers, not because he didn't want to, just because he was avoiding service.
Technically, yes. Again, the problem is always going to be convincing those officers that are going to be like, well, there was no arrest, she didn't really help, I'm not going to sign off on it.
I
And then-
come across that, the problem I come across is they don't know what a U visa is, so I have to go and explain to them everything. Every time I go with a new sergeant, but, they usually sign them off.
And you must be going to some really good sergeants.
But I have to explain, I
Mhm.
print out the copy, like, this is what a U
Yes.
visa is.
Exact good
It's not
idea.
like you giving them residency. it's
Exactly.
just saying that they have cooperated with the police. So,
Mhm.
okay.
We have, sorry for intervening, we have a close relationship with the sheriff's office in Gwinnett County. And the person who is in charge of everything that is related to domestic violence right now, he's Latino. So he's very willing to help out, you know, educate other law enforcement officers, help other advocates in the community. So if anybody wants or needs some help with that, you can contact Frances or contact myself. I'll make sure that my cards are also available, but you can always contact Frances. And we will be happy to connect you guys with them. Any help, he's very, very interested in helping. Even beyond his county, obviously his reach only gets into Gwinnett County. But he's always happy to serve as a liaison, and he has done that for us in the past in situations that they are needed. So if he has a contact and he can help out, he will.
Thank you.
And then on that same topic, these aren't things that they have to sign off on. It is 100% in their discretion, and there's no appeal process. You can't just say, he didn't sign it, I want to talk to someone else about it. Most of the time, once they say no, it's no, unless the position changes hands and then a new person comes in or regulations change. But there's no way to go back and say, actually, I want you to do it, and you have to do it.
What we encounter, like I said, is we're down south, we're in Warner Robins area, so the resources are very short, very small, and I think it's a lack of information that they have right now. And that's what we're trying to reach out to, even the police department, and doing roll calls and all that. I think that's our issue though, is a lack of information in certain areas.
Yeah, that's been our experience at the police department in South Georgia. Usually when we send them requests to sign a U visa, even when we send them tons of information, they literally reply, I was like, what's this? What do you want me to sign? I'm like, well, I sent you the packet. Did you read it? No. I'm like, okay. Well, I'm going to summarize it for you. And then they're like, and what's that? I'm like, okay.
Yeah. They're like, just sign.
Yeah, just if you could do me the favor, just where I marked it, you know. Yeah. That's a good one.
That might work. I'll be like putting your address, phone number, everything attached right there, just put sign here.
Yeah.
This is what we're gonna do.
So the thing is, like Carla mentioned, they have absolute discretion whether they want to sign it or not. You can't sue them to force them to sign a thing. Like if they want to, yes. If they don't want to, no. Now there are police departments that it's just a blanket no, period. Smyrna, blanket no. For the longest time, Smyrna was actually one of the best police departments to get certifications, and apparently from everything we found out was that they got overwhelmed, and then they were just like, no, we're just not going to sign anything. And they've actually gotten kind of nasty about it because there are other people that still keep trying, and then they've lost their cordiality about it, so they're very rude about it now. Roswell Police Department used to be terrible. Now they're kind of like coming around on the idea. Atlanta City used to be awesome, then they got bad. Now they're starting to come back, you know, because I guess we got a new mayor and things are a little different. So it just depends, you know. It's funny that she mentioned Gwinnett, because Gwinnett is actually, they have like, you know, what's that called? Like a flow chart with regards to how they decide whether they want to sign it. It's like, was this a qualifying crime? If yes, you go to the next step. Was this person arrested? No, then no signature. Yes, then they kind of go through that program. So you have to do their own flow chart before you even go asking them about it, because most of the times it's like, has there been arrest? Not yet, then no. So each county is different. Like Cobb, they have a rule that if it's older than 6 years, they're not going to sign it no matter how good it is. So it's just every county, every department just has their own set of rules. If they know about it, if they don't know about it, then usually you're in luck. So you're the first impression, so make sure you make it a good one.
Yes, please.
Yes.
So if the person gets the U visa, they make the application, it's sent. They cannot still get their driver license the same way that you cannot have a work permit?
No, because they don't have a work permit at that point. Once they do get a work permit, then they are eligible to get a driver's license. Yes.
They would have to wait for the maybe 8 years.
Correct. Yes.
Yeah.
The other thing to remember is, remember that if these cases go through the police and there is a court case, if the police says no, don't stop there. If there's a court case, try to go ahead and talk to the solicitors, because they can also go ahead and sign.
Mm-hmm.
Okay? Even if the police have already said no, the solicitors make their own choices based on their facts.
Yeah.
I have a random question. So with the U visa, say a female applies for the U visa, the man got arrested, everything, and she's driving and she gets stopped and she's undocumented. Can she be deported even though she has a U visa?
So she would be placed in removal proceedings. Doesn't mean that they just put her in a car and deport her right then and there.
Yeah.
Now, that comes with some caveats. If she had a previous deportation order, then they would try to reinstate it. If she has never had a deportation order and never seen a judge, then she would go through immigration proceedings, which is what I was talking about earlier, that even if she has this U visa pending, that doesn't protect her from going into all those proceedings. She would still have to try to get a bond to get out of detention if she can, or she would have to take an order and then wait for her visa in her country.
That's where she would wait for like
Yes.
8, 9, whatever. 10 years.
Correct. Now, the other thing is, a lot of times we get the question, well, what if I come back? They're not supposed to come back, but if they do, it doesn't affect their eligibility for this U visa. Doesn't matter how many, if they want to play ping pong at the border, that is perfectly fine. It does not affect their eligibility. There are very few things that disqualify you from a U visa.
There's really just one thing. If you're a person of national interest, aka if you're a terrorist, you're disqualified from a U visa. But you could, I had a client that had 2 convictions of possession of cocaine with intent to distribute. She was deported 8 times. It was just a disaster of a case. And she is now a green card holder.
Because that's another good thing about U visas. You have your visa for 3 years. They give it to you for 4 years. At year 3, you're eligible to apply for residency. Okay? And then once you're a resident, citizenship. But it gives you a clear path to be a citizen.
By the way, that sounded really bad. So she's actually a very nice lady. The convictions came because she was, as many of you know, with the wrong person. She took the blame for his dealings because she didn't want him to get deported because the kids and her depended on him. So when they pulled him over and they found everything, both times she took the fall for him. And it was bad because he ended up, leaving her anyways, and that's how she ended up in this deportation mess. It's a really sad story. So, and it wasn't even because of that she got the U visa. It was actually because her older daughter was a victim of rape. So it is a terribly sad story. So I saw some of your faces like, really? What? And I said, no, she deserves it. She's good. It sounded way worse than I said it. So. Sorry, but it's a good example so you can see that even in the worst possible scenario, you're still not disqualified for a U visa. So, yeah.
So it might be a dumb question, but for example, if somebody hires an undocumented alien, and then they just throw him away and say, no, I'm not going to pay you because you don't have any documents. I don't care. You can go to the police, whatever. Would that be considered something for a U visa?
No, that would not be under one of the qualifying crimes. There are very specific crimes that qualify for U visa.
Okay, thanks.
Yes. And actually, at the back of the room, we do have a little brochure.
Yeah, I have
Yes.
it. I was just
So.
right here.
Yes.
So
I don't know what's on there, but I'm guessing that the categories are probably listed on there somewhere.
And if they're not listed, if you again,
they are.
Okay.
Okay.
I was like,
they better be. They better be.
They should be.
Yes.
Okay,
Yes.
but
Yes.
yes.
Okay.
When you're saying U visa, are you also including VAWA visas?
No, so those are 2 separate things. For U visa, the person doesn't have to be a U.S. citizen or a lawful permanent resident. It could be any person, even if the other person is undocumented. For VAWA, the person has to be a U.S. citizen or a lawful permanent resident, and you have to be able to prove that.
The person that commits the crime.
Exactly,
Right.
sorry.
Mhm.
The perpetrator.
And so you understand the process of the U visa. So let's say once you get it for 4 years. And after 3 years of, being continuously in the United States with a U visa, you can self-petition, aka you can apply on your own for a green card. You don't have to have anybody else petition for you. So you can go from having, like I said, 2 convictions for drug offenses and 8 deportations to being a green card holder because of the U visa.
And a very good point that he just mentioned, you cannot leave the United States with this visa. It is a visa to stay here until you get your green card, and then you can travel. You cannot leave the United States while you have a U visa.
You can also not refuse cooperation while you have your U visa. So let's say that you, for 8 years, cooperate with like a really big case, then you get your U visa and you're like, psych, I'm out, you know? Because when you apply for your green card, they're going to ask you, we either need another supplement from the police stating that you have not refused to cooperate, or we need a sworn statement from you about what your efforts are with regards to the police. They will call the police department or the prosecutors and see if you've been cooperative. So if you were not, then they can literally be like, your green card's been denied and your U visa has expired, so you go back to 0. Yes.
Do you have to only cooperate regarding that case, or do you have to cooperate if there's another case that you have knowledge of or something, and you don't want to cooperate in that instance? Can they still revoke you?
I mean, as an attorney, I would recommend that you cooperate generally, but for the U visa in particular, it has to be for the crime that you were certified, or for the offense that you were certified for.
For somebody that works in a prosecuting agency, if the victim is very reluctant to cooperate and signing affidavits and wanting charges dropped, and they do have a U visa, we will call, USCIS to let them know the victim is no longer being cooperative. Because we have had cases dismissed or no pros because of victims not being cooperative.
Yeah. I've seen people that they started their U visa with other attorneys, and once they got the U visa, they try to marry the abuser to try to get them included in the U visa. But jokes on them.
Yes, you guys.
Yeah.
This happens every day.
That happens all the time. Jokes on them because they married them after they filed the U visa, so you can't include them. So you can't include them, and you're out of the U visa. Yeah. All right.
All right. Now, for our other type of visa, T visas. Those are for people who have been victims of human trafficking. We see this a lot with people who come here on work visas, and then their bosses take their documents away, and they're like, okay, you're here, but you're gonna live under my rules, and you're gonna do everything I do. No phones for you, no nothing. And that's essentially, they're being treated as if they were victims of human trafficking. Most of those certifications come from the Department of Labor. They can also, again, come from police departments and prosecutors. T.
Yeah, for trafficking.
Did not hear that.
Yeah.
Sure.
So I have a client that I think she may qualify, or I don't know. She's a victim of this labor. That it's not like her employer holding her documents original, but he gave her the copy.
Okay, so
they gave her passport from the country, but they didn't give her the original employment permit card, whatever is immigration paper. And they also made arrangements, like in the contract, they say like we will be paying you $8 minimum and $12 this, but in reality they're not paying her anything. They're only paying her $400. And if any food she orders or any clothes she wants to have it, they charge out of $400 monthly what they have. So we are does she qualify in this situation that apply for T visa? She has to have law authorities have to be involved on this one.
Based on what you're saying, it seems she may qualify. I would need a bit more information. It's always better to get the police involved because they are violating the terms of their work visa, the actual employer. They have certain regulations that they have to follow. Now, a lot of times the victims don't speak about it because what happens? This is the only way that they come in here to work. So they're not supposed to, but a lot of times these employers put them on a blacklist. So the employer gets reprimanded, and then the client needs to understand that they may also suffer consequences as a result of reporting it. Again, they're not supposed to, and there's protections in place, but it does happen. So it would be something that you would let them know, hey, I would suggest you this is what could happen, but you could also be eligible for a T visa.
How long it takes them to get a T visa?
That depends on the certification process, who's going to be certifying. The Department of Labor takes a long time. Police departments take some time. But T visas, are they under the category for U visa? I don't.
No, there's no.
So it's a faster time frame than U visas.
So if they have right there, like if we help her to apply for TV, then she qualifies. So which means that she immediately lose her current status?
No.
She can still be in that current status because her
Current status expires probably within 6 months, I'm guessing.
No, she has a 2 years, work permit, visa, 2 years. And but her employment, sometimes under the name, then it says like she can work only with that employer, particular employer.
Yes.
She cannot work with any others. So she cannot leave her employer. If she leaves, then she has to go back to her country.
Not while the T visa is pending, because they're going to be investigating the employer for breaching their duties as part of the the visa contract.
Which means she can still work with that current work permit.
No.
See, that's so.
She won't be able to work with that current work permit. She would have to have it amended to be able to work for someone else.
So who will do the amendment?
I would suggest an attorney.
Strongly suggest.
Exactly.
Let me interject something there, and this is something that we see, and there are others in the room, other agencies here present that have legal, small legal programs. We are able to provide, we can pay for U visas, VAWA visas, and T visas for some of our clients. And there are other agencies here that have the same services. Through CJCC money, we are able to do that. But we always encourage people, even if it's not people that are coming through that program, that they need to go to an attorney. I cannot count how many horror stories have I seen in the 20 years that I've been doing this work of people that try to do the work on their own, and something happened. And if anything goes out of these specific parameters, then you have no knowledge and no chance of fixing it. It's like the DACA program. A lot of people try to do the DACA application on their own. The problem, and you guys are the experts, I'm not, once you presented your DACA, you could not amend it, right? You present your DACA request in the beginning when the program came in, and you cannot start doing amends to it. So many people presented the wrong application and had issues with that.
Not only that, you can't appeal a DACA decision. You can only refile. But if you refile, then your application has incorrect information the first time, or had the right information, and later you find out, oh, so I'm not eligible. I'm just going to refile and change it. It goes to the same A file, so they can see your previous application and see that you've clearly mislabeled stuff.
So many kids, that had the opportunity of getting some sort of relief through DACA, and because they try to do them themselves and they made a tiny mistake, everything was gone out of the window. So, just my 2 cents on it. It's very important that we counsel people right, that they need to find help for these matters, because this is way beyond what us in the room that are not attorneys can do. My 2 cents.
Thank you.
You don't want to interject?
No.
Okay. So, any other questions on T visas?
Not T, sorry.
Whichever one.
Do you guys have clients talk to you about like S visas?
Yes. Oh, that is the next topic.
Look at that. I say that because she asked me why I included S visas in there. I'm like, it's part of the topic.
Exactly.
Oh.
So.
Look at that. You're welcome.
Thank you. By the way, when he says he included it, he means he put S visa. That's all the guidance I have on that one. So as she said, S visa, usually called snitch visa, are for people who have information. Let's say DEA does this huge drug bust and they get all these people. Some of them may be undocumented, and they'll tell them, hey, if you help us with this huge case, we'll go ahead and give you a visa. That's the type of visa that we're talking about. This is an S visa or a snitch visa. So it's based on your help to them. Now again, all these things sound all very familiar because if you're eligible for an S visa, you may be eligible for a U visa or a T visa and all these other things. It just depends which one is better for you based on your circumstances, or which one we can get certifications and other things on. Would you like to add anything?
Fine. S visas are incredibly rare. There's only 50 allowed per year, okay? So it's not like anybody and their mother can get an S visa. I've only seen one in all the times that I've been doing this, and I remember going with a client to CIS, and I told them, the officer will not know what we're talking about. I'm going to go ahead and tell you, so we're going to request a supervisor from the minute we get there. So when we get there, the officer was like, all right, so this is an adjustment based on what's that? So I explained it to them, and they literally just looked at me and just went like flatline. They're like, I'll be back. They left for like 2 hours, and then they finally came back. They're like, okay, a supervisor's coming in. I'm like, thank you. That's exactly what we're wanting. So it's not simple. It's very rare. It's a local police officer cannot certify you for an S visa. It needs to be a federal agency. It's a different process. You can't just be like, hey, I think I'm eligible for an S visa. Do you think I can go ahead and apply? No, they have to offer it to you. You can approach them and see, hey, I have a client that may have some information that might be vital to you. But if they really, really, really wanted the information, they probably already know about your person or your client, and they already offered it. It's very rare that you think you really have someone that has all this information. The client that I had a lot of information from the FARC from Colombia, and I mean like big time. Like he was one of their primary doctors, forced primary doctors. So he had some incredible detail with some very high-end people over there. So I'm talking from like, this person has a limp, like a gimp on their leg, operated so-and-so person on this, so they have like a pacemaker. Like he had some super details. And even him, like there was a question there for a while whether they were going to give it to him or not, because they kept going back and forth. That's another thing. Believe it or not, the federal government sometimes offers stuff and then they don't give it to you. So it just happens,
Make sure you get it in writing.
Yeah, you try to make sure that when they say they're going to give it to you, I'm like, please write that down, So.
Yeah.
You said only 50 a year, is that for the country or?
Yeah, overall. So they can offer it. The thing about the S visa is that because it's so limited and it's so rare, they can literally give it to you whether you're in the country or out of the country for you to come here and stay here.
They can actually parole you into the country.
Mm-hmm. So like if you have information on the election, hijacking, whatever you want to call it, and you live in Russia, like they can bring you from Russia with an S visa, something like that. Mm-hmm. By the way, I'm not political. I'm just saying it's a random example that came up to my head. So.
Are you seeing SB visas?
SV?
What's the visa you're talking about?
S visas. Yeah, like snitch. Yeah. They're not S for snitch. It's just the easiest way to remind. It's the easiest way to remind people what it's called. So, yeah, do not go somewhere else and call it a snitch visa, because that's not the correct term.
But they will know what you're talking about.
Yes, they will absolutely know what you're talking about.
All right, so the final on my subgenre on my topic is special rule cancellation. These are for people who are currently in proceedings, and it's very similar to VAWA. It just has a 3-year good moral character and presence in the United States requirement, and you have to show extreme hardship to yourself or to a U.S. citizen or LPR child, lawful permanent resident child, under the age of 21. The good thing about these is that you immediately get a green card. You don't have to go through the being in a visa, waiting 3 years, and then applying for your green card. If you win this case in court, you automatically get your green card. Yes. Okay. So these are for people who are currently in removal or deportation proceedings. Okay, so you have to be in proceedings in order to be eligible for this benefit. All right. This benefit, in order to qualify, you have to have 3 years of presence in the United States, and you have to be of good moral character. What does that mean? So no big crimes, because some crimes are okay, but let's just say big crimes. And then you have to have been abused by someone who is a lawful permanent resident or a U.S. citizen, or your children could have been abused, again, by someone who's a lawful permanent resident or a U.S. citizen. Okay. And then the good thing with this is that you immediately get a green card once you win this benefit. You don't have a 3-year visa period. Okay. Yes. Okay.
I don't know if my client, she seems like in a very similar situation, and that in her case, would it be really helpful, like her child is a U.S. citizen and she doesn't have a document and she has been here, she doesn't qualify for any kind of visa, she has been abused, but there's no proof. It's like we don't have enough evidence to apply for one particular, category type of visa. So she's in the middle, like
And she's in removal proceedings? She's in court right now?
No, she's not.
Okay, so she does not apply for this benefit. You have to be in immigration court to apply for this benefit.
Oh, so you need to be actually in the court to be.
Yes, like in proceedings.
And this is called again?
Special rule cancellation of removal.
Special rule of cancellation of removal.
Yes.
Is there,
Go ahead.
When you say abused by LPR, are you comparing it to like the law where they have to have them like married, legally married, or is it like, what do you mean like by abuse just by the? Because my vision of abuse is very different. So I don't know if it's like, let's say your child was sexually abused by somebody, so when you say like abuse, it's like mom, dad kind of thing. They were both married, and now you're in removal proceedings.
Yes.
Kind of thing.
Yes.
Okay.
So if the applicant is claiming hardship to themselves or abuse to themselves, then yes, they needed to have been married. Now, if they're claiming abuse to their children, then at that point they don't necessarily need to be married, as long as it's the children, it came from the relationship. Okay. The other thing is that for a special rule, it has to be, you have to prove extreme hardship, but the abuse can be battery, like being battered, or extreme cruelty. Okay. So it kind of goes hand in hand, but I've made different arguments that extreme cruelty is just more of a emotional state of things, with regards to treatment. So, yeah. So I'm sorry?
But not sexual.
It doesn't have to be sexual abuse.
Verbal abuse?
It can absolutely be verbal abuse. The last case we won was actually mostly verbal abuse.
Can it be sexual abuse?
It can be.
So can that person be a person that was emotionally abused to the point that she had to be put in a mental location for
Absolutely.
She won't have, right? She'll have the paperwork that says she were, and then she can apply for.
Yeah, that's another case we recently won. It was a case where the dad was in Stewart detained by immigration, and while he was detained, the mother of the children, who was a drug addict, basically neglected the children to the point that one of the children became suicidal and he had to be institutionalized. So then the mother got arrested for a very serious drug offense. Dad essentially became a single dad. The kid is still under severe treatment for mental problems, and it all arose from the fact that the mom really just neglected them. So.
One last question, I'm sorry. If the parents are not married, as long as it's like a prior, does that have to be like legitimized, child?
Hmm?
You have to prove like legitimacy.
Yeah, or like for example, if the dad is in the birth certificate, so usually they'll take that whether they're married or not. If a kid is not in the birth certificate, so there's two ways. Georgia, even if you're not married, and the rule's kind of weird because I've seen it both ways. Georgia will allow a parent who is not present during the birth to later sign for, like, stipulate for the mom and the dad to stipulate, yeah, you can go ahead and add me to the birth certificate because I am the father. And I've seen that work for the most part. I've seen other people say that the state refused it because they want like additional proof, like either a legitimation process, but then that defeats the purpose of having this form if you go through a legitimation process. So it's just, I think it's who you get when you go to viral records, basically.
Yeah.
Did you have a question, ma'am?
Say, was your question answered?
Okay, no problem.
Any other questions? All right, then now it is Gadiel's turn.
Okay, so now it's my turn. I'm gonna be speaking about recent changes in asylum. God bless you. Some recent changes in asylum. This is something that I'm pretty sure almost all of you have heard in the news. Basically, asylum is under attack by the administration. You can see that with the recent restrictions that they have been imposing. Originally, the way that you ask for asylum in the United States is that you just went into the border, into a point of entry, and asked for asylum, right? And then the process started. So now there is an asylum ban. Now they are requiring that when a person arrives at a southern border, they have to show proof that if they went through a third country to be able to get to the United States, like if you left from Guatemala, for example, then you have to apply for asylum in one of those countries that you pass through, Mexico, for example. So if you arrived in the United States, asked for asylum, and you didn't stop in Mexico and ask for asylum, and you can't show proof that you actually requested it, and it was denied or rejected, then the United States will reject you. You will not be given asylum, okay? At least to start the process, okay? So basically, this rule has been enjoined, but we're seeing that judges are still upholding this new ban, okay? It's different if you come in from Canada. Canada and the U.S. have an agreement that wherever a person arrives first, they have to request asylum in that place, okay? But mainly, this is another way to dissuade asylum seekers from coming to the United States, as well as giving another excuse for the government to be able to reject them, okay? So we're gonna see what happens in time with this new regulation. Okay, so the second one is asylum bonds. So usually when you get to the border and you ask for asylum, or you get there, you can be given an expedited removal. Okay, if you don't have any other form of relief, they can give you an expedited removal, which means that you will be sent back to your country. Unless you request asylum, you have a claim of fear to return to your country, and you pass a credible fear interview. Okay. The problem is that if you pass that credible fear interview, you're still in detention, in a detention center, okay? So the problem is that now there's a new case, matter of MS, where these persons who have an expedited removal and pass the credible fear interview, which means that they're gonna be given full proceedings to fight their asylum case, are not eligible for bonds to be able to get out of the detention center. So this means that if you're gonna go through fighting your entire case, you're gonna have to do so from the detention center, and I don't have to tell you that how the conditions are there. So this is another way to dissuade them to pursue their entire case. So this means that you can't go before a judge. A judge won't have jurisdiction to be able to issue you a bond, even if you have the best case ever. Okay, they just have no jurisdiction. They cannot see it. There's another recent injunction on federal courts by the federal court to not allow that to happen, but judges are still upholding it. Okay, the one thing you can do. There's a couple of things you can do. You can go before a judge to request a bond, but what you can do is do a parole request. A parole request goes directly to the immigration officer, to the deportation officer that is in charge of your case, and you explain your case, and he has discretion on whether to allow you to enter, to be released on parole. Okay, and that way you can get out of the detention center and continue to pursue your case. Okay, or the other option would be if you're able to make ICE agree to give you an ICE bond, which is similar to the immigration bond issued by a judge, but in this case by a officer, immigration officer. Okay. And the third restriction is there's a focus on recent border arrivals. It's called like the rocket docket. This means that before, when you ask for asylum, the process could take years. The court case could take years for you to be able to have your individual hearing, which is your merits hearing, where you fight the case. So now family units that are coming into the United States, this means mother and daughter, father and son, or the entire family unit, mother, father, and however many children. They are putting this expedited court calendar where your court dates are basically 2 to 3 months apart from each other. So asylum cases that were about 2, 3, 4, 5 years, now they're being seen for family units in 5, 6, 7, 8 months. All the hearings, submitting up applications, getting all the evidence, and going and fight your case. The effect that this has is significant because what they're effectively doing is restricting the possibility of the asylum seeker to have a work permit. Because for you to have a work permit under an asylum application, you have to wait 180 days after it has been submitted. Okay, so this is 6 months. So if the cases are being resolved in 5 to 6 to 7 months, you're probably not gonna get to the entire 180 days to be able to get your work permit. And this is worrisome because if you want to have good legal counsel, how are you supposed to pay it if you can't have a valid legal work permit in the United States? So those are the things that the administration is doing to try and control asylum cases, asylum seekers, dissuade, reject them, and basically give them no help regarding how they can fight their case and be able to obtain an asylum visa, which is very difficult in itself without all of these restrictions.
And one thing I forgot to put in there was that another thing that they did, but this was not recent, this was a couple of years ago, 2017. So like Adiel said, asylums used to take a long time. So like people would apply, for example, Venezuela has been like the country that's been applying for asylum the most of the last couple of years. So a lot of people would apply and then they would just kind of wait it out because of the fact that they had time to build their case and build their evidence, so have a few years. So the administration changed it to basically like LIFO, last in, first out. So if you apply today, they're like, okay, so your interview is going to be in 40 days. So if you just arrived at the country and you didn't have time to, the last thing when you're fleeing is for you to grab all the evidence and all these things to prove. So most people will come and then they don't have the evidence, so they will lose out on their case. That's done completely on purpose because for years, I'm talking decades, it was always you apply and there was a line and we would take care of you accordingly based on the line. But now they switched it up that way. So if you're a recent asylum applicant, they'll try to get you out as fast as possible. And like I said, to dissuade you or keep you from obtaining a work permit whatsoever. So all these changes are intentional, obviously, to dissuade people from wanting to apply for asylum, whether they have a good case or not. Yep.
My husband came as a refugee status. So what's like the difference between the asylum, the refugee, and the one in great? I'm just curious at this point, like what made these different than?
Well, it's interchangeable. So, the word refugee is basically the description of how someone would be eligible to apply for protection. So asylum is something you apply for here. You apply within the United States, you're here, so you apply. When you apply for refugee status, you're essentially outside of the country and you're applying to come here because you're seeking to be refuged. So, but even during asylum process, they talk about the difference of a refugee versus an applicant. So in essence, it's a little interchangeable in that way, but the best description is just asylum, you're already here, refugee, you're coming from another country. No problem.
Can you explain a little bit more about being bonded, either the ICE bond or the bond from because people don't know what does it give them?
Okay, so when you can end up in a detention center for various reasons. It could be once you get into to the border, they will detain you, and the officer has the discretion to either release you on your own recognizance, or they can issue an ICE bond, which is basically that you pay an amount of money, which serves to guarantee your presence in court proceedings or reporting with the immigration officers, so that they have So they can keep tabs on you, basically. So they know where you are, and they're sure that you are complying with all of their conditions, okay? The other thing that I mentioned was the parole request. So the parole request is something that you send directly to the officer, and he considers it, and in his discretion, he can either grant it and release the person under parole, or he can deny it and the person stays detained. Usually, on a parole request, you don't have to pay a bond. So it's even better, but it's not easy because it's his discretion. It's whatever he thinks. If he thinks you're gonna be a flight risk, he's not gonna give it to you. So the other part is that you can be a person, you entered through the border, and either you had an immigration encounter or not, and you are in the streets and you get arrested for no license or for anything else. ICE can put a hold on you, okay? So they can put a hold on you, and then once your case is finished, usually it's finished or not, they can grab you and you'll pass to an immigration detention center. To be able to get out of the detention center, the only way would be through the other one that I mentioned also, but in this case, you may also be eligible for an immigration bond. So basically, you go before a judge, and a judge will determine if you're a danger to the community and if you are a flight risk. Okay, danger to the community, of course, they will see your criminal record to see if you have crimes, serious crimes that they don't want to let you out because you can cause harm to somebody else. And flight risk, meaning that if you don't have, what they look into is that if you don't have a good relief, a strong relief, or any relief at all, then they're pretty sure that if we let him out, he's not gonna go to court. He's just gonna he's gonna flight. He's gonna leave and just be on his own and be a fugitive, basically. So if those two are met, an immigration bond, a judge will usually issue a bond. Okay, once you pay a bond, then you'll be released from jail, and you just have to comply with the conditions, either reporting to the immigration officer, going to the immigration court, or both. Okay, and as I said before, if the bond is not granted or the parole request is not granted, and you want to fight your case, you're gonna fight it from the detention center, and that can take months. And many of our clients, they go, it's hard for them. They basically go crazy. They're like, I can't stand it anymore. I can't be here. I'm just gonna sign the order or voluntary departure. I gotta get out. And they may have a good case. Maybe you don't win it before the judge, but you could appeal it, and maybe the Board of Immigration Appeals can approve it. But they don't give you that chance if you can't, be released and prepare yourself and not have to go through the burden of being detained in those conditions.
And like you said, some of these cases take months, some take even years. Right now we have a client who's been in detention for almost a year, and his case hasn't even finished, which means he has the potential to be there 2 years at that if he appeals his case and so on.
I just read that somewhere yesterday, the two brothers were being detained, and the detention center was so deplorable, the conditions were deplorable. He called it self-deport.
Mm-hmm.
The one brother self-deported after not a month or so, and where the other brother stayed and went to about 2 years, and he finally got his visa or whatever.
Mm-hmm.
Good for him.
Wow, that's good.
He self-deported because it was just terrible.
Mm-hmm. I mean, they're terrible when even as an attorney you go and it makes you cringe, and the treatment that you get is subhuman. So you can only imagine how they're treating the detainees and the people that are in there.
Yeah. Yeah.
Mm-mm.
So what do we do with the ones that have children in the other detention centers? I mean, how do they apply for those kids that are out there?
What do you mean?
Usually
You mean-
they don't keep children in detention centers for too long. They will release them on parole. Is that what you're asking about?
Do they grant them the parole? Do they have to be a certain age?
Usually minors, I would say.
So what generally happens with children is one or two things. If they're unaccompanied, they'll try to find a relative or a family friend or somebody who's willing to take them in. They'll make them fill out like a 3-page packet, and once you send it in, they're like, all right, here you go. Here's your kid. But if the kids came in with the parents together, obviously there's huge hoopla about the separation of kids and everything. So that's a separate issue. They're trying to undo that a little bit because of the hot water that came under the administration. So it's rare to see that now, but it's still happening to a certain extent when they separate them. So they go to a separate, they don't call it a detention center.
They're like shelters.
Yeah, they call it a minor shelter. It's totally a kid jail, but it is what it is.
Yes, two things I would like to understand a little bit more. So it is it's an optional for the officers to see the way that the person that has been catching the border, what kind of process this person should get through.
Yes.
It's gonna be always at their discretion.
Yeah, it's their discretion. I've spoken to some of them, and I've asked them in Cobb County, there's an ICE officer there in the jail. So I asked him one time, I'm like, so how do you determine who you're gonna give an ICE bond? You know, an ICE bond, you don't have to go before a judge, and that's immediate. If you receive an ICE bond, just pay it and be done with it.
Get out
Be
fast.
done with it. It's too much. No. Don't forget about that.
They are a bonding company.
So exactly. So he told me that, you know, they kind of look through their case, see if there's some relief. They mainly look at how many years they've been in the United States. They look at if they have family with U.S. citizens or residents, you know, that they know that can make them qualify for other reliefs. So if it's that kind of a situation, or married to a U.S. citizen or LPR, a lawful permanent resident, then they know that they probably haven't started the process yet of the family petition, but that's something that they will probably pursue now that they are under their, there will be court proceedings. So in those type of cases, they give them a bond because they know that, or just release them because they know that they will be able to adjust or obtain another some form of relief, which is pretty much guaranteed, you know.
A better process.
Yes.
Okay. And related with expedited court calendar, would you say that in the cases that when I hear about and I read the news about the mother that was separated from her 5 months baby girl, and they came together after 3 months, I think so. So would you say that what happened in that case was something related with the expedited court calendar? That each one of them were running in a different process, and that's why they had to encounter each other after that kind of.
You mean that they were reunited?
Yeah.
If it's because of that, well, I don't think there's a relationship necessarily. It could be a coincidence. However, it should be their policy to keep families together. What I can tell you about that expedited court calendar is that if you arrive in the United States with your children, you'll probably be considered a family unit, and you will be part of that expedited court calendar of hearings.
And if for whatever reason the cases are not together, and the person goes to court without an attorney, and they say, well, my kid has court next year, and all of a sudden not, and they're just like, oh, you have a kid that's also in court? What's their A number? And then they'll add it to that case, like automatically.
And then they'll make it an expedited case.
Yes.
So, correct.
That's
Separate,
what they want.
They would have been not on the
Right.
expedited calendar, kind of taking their time with it.
Not together.
Yeah. I've seen people also that say, well, I'm going to go to court by myself, and I'm going to tell the judge to give me my kid's date so I can be over there. I'm like, yeah, that's totally going to work. Go ahead and try that. What they do is they bring the kid's case faster.
Yeah.
So, yeah.
I have a different question, different visa benefit. So, you know, I want totally that you can petition for your relatives. A form has not been printed out from the USCIS website. Is it canceled or something?
The form to petition for relatives?
Yes.
That might just be a glitch.
just a glitch, or it has been like it's almost a week now, so people cannot print out or
I have not noticed anything like that with our.
We print those out every day.
Yes.
No, it might be so.
Make sure that you're on
Okay.
USCIS.gov.
Yeah.
Because there are some .com and .net. And all of those.
Yeah. Also, if they're charging you, if they charge you for the form, that's also a huge red flag that you're in the incorrect website.
And that could be the reason.
Exactly.
So sometimes I just click it and I'm not even paying attention. I'm like, where is it? I can't find it. And then when I look at the address, I'm like, okay, this is not it.
Yeah, and they purposely make them look identical.
Exactly.
And
So
that's
just
the
make sure
first.
that you're on the
That's
right one.
I guess they pay money, so they're the first one in the search.
Yeah.
So for USCIS, which is the official one, which have all of the information, it's like the 4th or 5th. So you always have to scroll down.
Yeah. That's another thing. I'm about to get on a soapbox really quick, but if you get someone that says that they went to an attorney and the attorney charged them to print a form, like,
Shady attorney.
yes, that's not the attorney that you want. Because I've seen like people that come, they're like, oh, so this attorney charged me $700 to print the supplement B. I'm like, I give them out for free.
Yeah.
Like there are a lot of times that people, like depending on the police department, where like you might have a better luck if you go by yourself because they hate attorneys over there. So you go by yourself, you get it signed faster and just bring it back, and then we'll do the U visa. And I print it out and I give it to them. So this attorney was doing the same thing, was charging them $700 just to give them the form. I'm like, hey, to go to the public library, print it there, it'll be so much cheaper. So somebody had a question. Yeah.
So I have a question and then a comment. Unfortunately, we see a lot of families who are not necessarily communicating with the best attorneys, but the attorneys give them some sense of hope. And so that's what they hold on to. And so we have families who are paying thousands and thousands of dollars, even though in reality, it's not going to happen, but the attorney keeps saying yes, maybe, or not even yes, but maybe, and so they're like, well, maybe if I give them another $1,000, it'll be. So it's something that we in the school system, and I know that the parent facilitators that work very closely with families see this unfortunately very often, so it's just communicating. But my question is, so about 12 years ago, we had an agency, we being Cobb County Schools had an agency come and present to us and give us a packet of what they recommended that undocumented parents fill out and have in their car. Because at that time we were having a large number of families that would drop off their kids at school and then drive a mile down and be stopped and picked up. And so it was recommended to have the families fill out this packet to have with them, and it was, information of, this is who I am, this is where I live, these are my children, I'm the sole provider, this is where I work. Is that something that you would suggest that we continue to encourage, or no?
I would absolutely say yes.
Yes.
Okay.
I don't think there's nothing as overkill with regards to immigration. Like, having information and being able to present your case as much as possible is always ideal, which actually brings us to our next topic, which is the new expedited removal rule. So another awful change, and this one's kind of quick, but it's probably one of the scariest. Under the new regulation, under change of rule, if a person is stopped, or encountered by an immigration officer, and that person was determined that they did not enter the country legally, if that person cannot show that they've been in the United States for 2 years continuously preceding that, encounter, then that person can be ordered expeditedly removed from the country without seeing a judge, without presenting their case, period. So having a packet like that would be ideal, because then if you have that encounter, they're like, this is where I went to have my child, and this is where I went. So that's, better. But the problem now is that with this expansion, if you can't prove that you've been here for the past 2 years, they can just deport you without you having the right to go before a judge.
It's also always good to have someone else know where your bag of goodies as far as evidence is, because most of the time you don't just carry that around with you.
Right.
Yeah. And that seems to be a problem with, a lot of the communities, that people think it's better to not leave a paper trail with regards to, because they're like, oh, well, if I leave a paper trail, they'll know I'm here. I'm like, well, if you don't have a paper trail, then you cannot present a case that you've been here, because most of the reliefs involve you proving that you have been here, that you didn't just get here. So
I've seen an increase of families coming in and requesting proof that their child has been in school
Yeah.
for a period of time, and I'm assuming that
Probably.
Yeah. Yeah.
For that.
Something that I would like to mention, because I think it's very pertinent to everybody in the room. The first thing is that there is a document that was prepared by a group of attorneys and a group of nonprofits, that it has been distributed, to the community. If you don't have it, it explains what to do if you're stopped by ICE. It does has a lot of good information. We have that document.
No,
We
Kevin
can
no la ha
happily
puesto.
distribute it to all of you. We have put it also in our Facebook page, so you can go there and get it.
I don't know
And
if I want
sometimes
this
people
other
don't
people
realize
watching
the power of these things, and I was looking through my phone because there was an interview last Monday at the New York Times by the acting director of ICE nationally. And he was saying that one of the things that avoided, that impede them to do more arrests on the weekend that they were planning to do the raids, was how vigilant the community was. And actually quoting him says, I don't know of any other population where people are telling them how to avoid arrest as a result of an illegal activity. It certainly makes it harder for us to effectuate those orders issued. So we have power. As a group of community advocates, if we educate ourselves and know what to say and know where to go, then we have power. The community has a lot of power. So it's important, that's why we are doing this, and that's why we intend to do, we're gonna start a large project in Gwinnett County, which we will get to you guys, because we need a lot of the power in the room to make it happen. But a lot of it is gonna be community education. We're going to be doing a lot of community education in Gwinnett, because we need to have more of these opportunities of asking questions. So,
Yeah.
Any final word, guys, that you want to
the last thing that we had really was just stats. So, again, I don't want to get political, but I'm going to.
You're in good company.
Yes. So since 2016, when we had a new administration, we've seen that immigration really has just become complex for the sake of being complex. Probably the best example I can give you is that USCIS application, the processing time for these applications increased 46%, even though the amount of applications being received decreased by 17% with the same amount of staff. So you're dealing with less work, but somehow you're almost doubling the amount of time, or in some cases tripling. For example, work permits used to take 90 days at most. Now some work permits take 10 to 11 months, 7 to 8 months on some, and it's not different. It's just they're purposely taking longer for the sake of taking longer, Then you talk about, immigration court and arrests and everything. The reality situation is that, as much as people like to talk about the previous administration, the reality is that Obama's administration was, consistently staying in the same numbers, but there were high numbers of removal. In 2013, 2014, those numbers spiked because there was that border surge. But after that, they just kind of stayed the same. With George Bush, it was actually almost like a straight line, almost the same numbers every year. Since Trump came into power, when he started mentioning his plan, I specifically remember telling everybody, and I went on Univision and said this, I was like, you're going to see a spike in arrests, but the deportations are going to go down, because you cannot cast that wide of a net and think you're going to get them all out. That's exactly what happened. Arrests for 2017, which is the first full year that Trump was president, went way up, but the number of removals or deportations went down, because they don't have enough, judges to see all these cases and whatnot. Furthermore, what happened after that, they're like, okay, so we don't have enough space, then we're going to start reopening old cases that had been closed. So next thing you know, when Obama left, the White House, the amount of cases in court were, be exact, because we have a lot of stats. It's 516,031 cases. The next year, Trump raised it to 629,000. The next year, it got raised to 768,000. And as of today, there are 945,711 cases in court, but about the same number of deportations still. So what's happening? They're persecuting all these people, trying to put them in proceedings with no real end game as to how this is going to end, because you've basically doubled the amount of people that are in deportation proceedings, but you haven't added judges, you haven't added courts, you haven't added prosecutors. It's just the same system. So when people go out and say, well, the immigration law, they just need to enforce it, or they need to do this or need to do that, it's not that the immigration court or the immigration law is breaking. It's been broken for years. None of the things we've talked about today were actually changes in the law. All these were changes in policies. The INA has not had an actual revision since 1996. That's 23 years ago. Not one. So you're dealing with a almost 30-year-old law with an area that has changed substantially over the last 3 decades. So when you say enforce the law, sure, by all means go at it, but it's not going to work. And that's exactly what's happening right now. That was my final thought.
I see that, there are more people incarcerated, there are not enough judges to judge. Is this a profit because they are creating more detention centers?
Oh, the detention centers are definitely profiting.
It's just profitable for the people that is in power.
Well, the detention centers are profiting, but the cost to maintain those detainees is also rising. So the detention centers don't care. They're like, oh, we have this cushy government contracts that pay us for this, but it's the taxpayers that are paying all these, so when people say, oh, well, detain them all, you're paying for it, dude. So
Exactly. And we just
We're
spoke.
not getting rich, but somebody's rich.
Exactly.
Other
And we just
people,
spoke about public charges.
Yeah.
If you're detained, you are a public charge when you can be outside actually being productive for work that is needed. So, it's also a philosophical type of issue. It's not something white or black, but we definitely need a change that benefits all parties. I know that's kind of utopia, but there's something better for sure out
And
there.
I just wanted to mention, if you guys want to keep up to date with like the latest information and stuff, I suggest that you guys follow us on Facebook, as Michael posts most of the videos to keep everybody up to date, just so you guys
Every
have an idea.
change.
What is it? What's the name?
The Urbina law firm.
Yeah.
Right here.
Yeah, you like it, you're subscribed, and
Exactly.
Yeah, we put videos in Spanish with English subtitles or sometimes in English, just to give like all these things that we talked about. We've already posted videos about information.
And I believe that this will be posted.
Yes, that this been filmed, the whole thing has been filmed, so that we can share.
Yeah, shameless plug. Tom.
Because you are attorneys on immigration, I have a quick question that is concerning me and other people that look more deeply about the situation of immigrants in the board. And it's about, I would like to ask you if you know something that can protect those persons in there. I know that the government is hiring doctors and put an offer for doctors to work in the board, offering a very substantial annual salary for $400,000 annual salary, with very low requirements. And the specification actually were mostly to be sure that they are gonna work with the government under their policies and their specific that, that makes a very big window. So do you know, because that definitely will create a big scenario that doctors can do with our people over there. Do you know if under the immigration law, is there something that the people can definitely have access to protect themselves to some specific practices that are not ethical?
So everything that we talked about today has been some sort of lawsuit, started based on it. Every time that I see one of these things, and I always post in our videos too, like I hear you, it's scary, but there's already a lawsuit that's been drafted to enjoin this or stop this. So the minute, these doctors start being hired and start working over there, I'm sure the ACLU and all these other organizations are going to immediately file a lawsuit to enjoin it. And it will be enjoined because it will be filed in the Ninth Circuit, and everything that is, anti-Trump will be granted. So it's just, I don't see that coming into effect anytime soon. It is scary, it is concerning, but none of these rules that we talked about right now are actual in effect. They have like a, secondary effect and how they are used, but they cannot enforce these changes just yet because all of these things that we talked about have been enjoined by lawsuits filed by big organizations with big budgets.
So, thank you. I didn't get to introduce myself. My name is Urbina. I am Executive Director for Familia, and we thank you for coming to one of our houses to get the information. We want to thank our Georgia Latinos Against Domestic Violence coordinator, Frances Munoz, for putting together these bi-monthly meetings. So every other month we meet and we try to bring information that is pertinent to your line of work. So Frances will ensure that all of your emails get into the information system so you get information about our next meeting. Thank you for the fellow domestic advocates here in the room. It's important that we work together. Thank you so much for our friends from the Urbina law firm for bringing the information. We are willing to put together informational sessions like this for you. So if any of you want to do like an informational session on any of your locations, we will be more than happy to make it happen. And I'm offering what I cannot give, but I'm sure we can arrange that.
You can count on us.
Yes. So thank you very much, guys, for the great information that you provide and for putting yourselves, making yourselves available for the community. So
thank you for having us.
Anything else that we can do for you, please let us know. We still have some spaces for mental health counseling free of charge. You don't have to be documented, you don't have to have insurance. And we have spaces both here in Smyrna, in Acworth, in Norcross, and Beaufort. So if there's anything that we can do for any of the people that you work with, just let us know. Thank you.
Thank you.
Gracias a todos por su atención. Esperamos que les haya gustado la información que vieron el día de hoy.
Si todavía no nos han dado un like, asegúrese de darnos like y por favor cualquier mensaje o pregunta que tengan nos las mandan por Messenger.
Gracias por su atención y hasta la próxima.